2005 thought that this stand your ground law was a good idea. And they were both mostly Republicans, but also Democrats who passed that law. But there are people in office right now who are sponsors of that law. Aaron Bean, who is now a state senator, was a co-sponsor of that law. Daniel Davis, who is a House brat, who is about to be the chairman or president of the Jacksonville Chamber of Commerce, was a sponsor of that law, co-sponsor of that law. Stephen Wise was a co-sponsor of that law. Our U.S. Senator Marco Rubio, when he was in the Florida House, was a co-sponsor of that law. And that law, as we heard from Reverend Jackson, encourages violence. And how does it encourage violence? Because, you know, the National Rifle Association will tell you that law came about to protect people. Really, that law was to protect gun owners, and that law unfortunately has the result of encouraging violence. Now, why does it encourage violence? It encourages violence because in 2005, when that law was changed, it didn't put into the hands of law enforcement how someone should react when there's a crime or when they perceive there's trouble. It puts it into the hands of someone like George Zimmerman, who might, for whatever reasons, perceive in his own mind, he might have gone to a movie that night and it was a horror movie, or something, not George Zimmerman, but anyone might have their own internal fears, perceptions, biases, prejudices, and the law has become such that the person's individual biases, prejudices, perceptions allows them under the stand your ground law to what they call, the law says, protect themselves. But as we've seen with the tragedy of Trayvon Martin, it allowed someone who killed another person to get away with it. And I'm going to read you the main portion of the law that was applicable in the case. A person who is not engaged in an unlawful activity and who is attacked in any other place where he or she has a right to be has no duty to retreat. No duty to retreat. That was not in the law prior to 2005. And Florida was the first state of all of the states in our union. First state. Now many states followed the lead of Florida after 2005. It was never in the law before. The common law, going back to ancient times in England, said you couldn't be the aggressor. You had to retreat if you could, which makes common sense. Because do we know, if you're not a trained law enforcement person, if you have certain biases, prejudices, you should retreat because you don't know what you're encountering. You don't know if it's a young man who's unarmed with a packet of Skittles, or perhaps in another occasion, someone where you're putting your life in danger. But in this instance, the law was changed to allow someone not to retreat. So if someone was armed with a gun and happened to like going to the target range and shooting at figures of people, or plays video games and they like to shoot people, they could look for trouble under this new law in 2005. So they don't have the duty, the obligation that goes back to ancient English common law times to retreat. And they have the right to stand his or her ground and meet force with force, including deadly force. And what has happened? We've gone back to the Wild West. We think we're heading, more civilized society where nonviolence, the rule of law is today. It should rule the day. That's not what our legislature did in 2005. It's not what our governor signed in 2005. These elected officials became the first state in the United States to allow someone to use deadly force, even though it wasn't in the past. Again, the ancient common law, if someone broke into your house and you feared, you might have a right, because that was in your house. But this law has changed. So now in the streets, we are in the Wild West. Okay? And in 2005, People weren't marching. People weren't saying, hey, what is our legislature doing? In fact, again, look at who sponsored this bill. Our U.S. Senator, Marco Rubio, was a co-sponsor. Our Aaron Bean, a state senator whose district covers Duval County, who just won an election, was a co-sponsor. Daniel Davis, who is about to be the head of the Chamber of Commerce here and has his district in Duval County, was a co-sponsor. So you can stand your ground, meet force with force, including deadly force, if he or she reasonably believes it is necessary to do so to prevent death or great bodily harm to himself or herself or another. That person's reasonable belief. So then what becomes the issue before the court? Well, what's reasonable to someone who happens to love guns, and there are a lot of people who like guns because they're sports people and they like to hunt. There are other people, though, who have more nefarious kind of views about guns. They might like the idea of being a vigilante. They might like the idea, if they were not qualified to be a police officer, to be a make-believe police officer. They might like those video games where they get to kill people all the time and go looking for trouble. Well, this law provides that a person who's got that reasonable belief, they put themselves in a position, can use deadly force. That means every one of us, we're out there and we happen to be in the wrong place at the wrong time, can be victimized by that person. And the law goes even further, because in fact, if someone's found to have engaged properly under the statute in this kind of stand your ground self-defense, you can't sue them civilly. In fact, if you lose a case against them, or the estate of someone loses a case against them, the court can award attorney's fees against the person suing them. This is an outrageous law. And again, this was a unique law in 2005. I would just take, who heard of this law in 2005? Right? Well, again, we have elected officials in office now who are co-sponsors of this. And let's give them the benefit of the doubt. Let's say they didn't really know the impact, or they didn't really know what the end result could be in such a tragedy like what happened with Trayvon Martin. Well, now they're in office, they're still accountable. And we have the opportunity to now go back and make sure they understand the displeasure of the citizens who vote them into office about this law. So any questions about the standing ground law? Yes?
My question is...
Come to the mic so everybody can hear you, please. Thank you, ma'am.
Hi, thank you very much for explaining this, because there were some things that I didn't know about this. But my question is, it seems to be some inconsistencies as to who this law actually applies to and who does not get the benefits of this law, as in the case of Larissa Alexander. I think what a lot of us do not understand is how is it that her case did not get the benefits of this standing ground law, especially pertaining to what you just explained. So we're just trying to figure out why is it this law is not applied to all cases.
That's an excellent question. And actually we had Ms. Alexander's attorney here who had to leave earlier, and he was sitting up here. My understanding is that Ms. Alexander had a hearing before a judge. So it's not a jury that would decide that stand your ground. There was a motion filed to address stand your ground, and she lost that motion. Okay? So the judge and Kevin Corbin, who was here, was her attorney at that time, could of course explain the specifics because he was there. But that's, and in the Trayvon Martin case with George Zimmerman's defense, they elected not to present that as stand your ground as a defense in the case, so they did not bring that motion. Because they did not bring that motion, other changes to the law, which had to do with self-defense, came into play and were part of the verdict, which makes it, again, change what had gone on for hundreds of years. Our law derives from the English Commonwealth. Change those laws and made it easier for someone to assert a self-defense defense. And that's what happened. But Ms. Alexander did present that. Yes, sir.
From what I understand, when the argument took place, what happened was she went to a car to get a weapon, and she did not initially have a weapon. And what I understand is because she left to get a weapon, they felt that she could have defused the place and exited the property. But she failed to do that and came back with the weapon. So they feel that Stenya vandalism.
Yes, thank you.
Yes, ma'am. Come on.
I just have one question.
You're okay.
It's pertaining, it is somewhat pertaining to, I personally think, we give honor to all of those that were here today. I thank you that I was able to come here and get a lot of experience and education on what we're facing. My question is this, that I'm so praying and looking at the logistics of the judicial system, and I know this, that it only took 2 minutes for Trayvon to die. My question is, how long do we gonna have to wait, or what process is it gonna take to get this law off the books? Because while we're going through everything we're going to make this right, how do we pressure the judicial system? And while we're doing this, people are still gonna be dying to get this off. It took 2 minutes, and I believe George Zimmerman watched them die. 2 minutes.
Let me answer your question. One of the things that Reverend Jackson was trying to make sure we understood, we marched then,
Yes.
and we got to march now. And it's going to take not just us, but the younger generation as well. You have young people sitting in the governor's office right now. So they don't plan on moving. I'll be with them tomorrow. They don't plan on moving. But I'm saying we've got to organize ourselves. We've got to do it in a nonviolent way. We've got to be strategic about what we do. We have an ace in our hand, but we have to hold on to it. But I will tell you this. Florida has the largest tourism business in the world.